Good morning, President Binder, Commission members, staff. My name is Brennain Lloyd from Northwatch, and we're pleased to be here before you. Took a moment to get set up. I had a perfect storm of technology failure this morning, so I've got a mix of different pieces of paper. Pardon me?
It wasn't nuclear.
It was not nuclear, definitely. This is Northwatch. So my name is Brennain Lloyd, and I work with Northwatch. We're a regional coalition in northeastern Ontario, and our focus today in this proceeding is on the radioactive waste management practices at the Chalk River Laboratory. So Northwatch and CELA have worked together to draft the joint submission that is before you. Northwatch's interest is in the potential for the radioactive waste management practices, programs, and endeavors at the Chalk River Laboratory site to be either precedent-setting or become normative in terms of decision-making with respect to nuclear matters in Ontario, and then potentially have future effect in Northwatch's area of interest, which is the neighboring 6 districts of northeastern Ontario. Our part of the focus has been to evaluate the waste management practices at the Chalk River site. And I'm joined by my colleague, Carrie Blaze from the Canadian Environmental Law Association, and I'll pass it over to Carrie at this point.
Good morning, Commission members. As you know, I'm Carrie Blaze from the Canadian Environmental Law Association, and as this is a joint submission from Northwatch and CELA, I'll just briefly introduce what CELA's component of the review was. So CELA sought to identify principles which should inform waste management, and so we conducted an interjurisdictional review of what are the best practices, the best principles, which should inform a licensing basis for waste management. So we started with a working definition of waste management, and we adopted the one used by the International Atomic Energy Agency, which I've included on this slide, and I'll briefly read for you. So waste management for our review included all activities, administrative and operational, that are involved in the handling, pre-treatment, treatment, conditioning, transport, storage, and disposal of radioactive waste. So our extensive review of international documents, treaties, and policies allowed us to identify 5 sets of principles, and these I've identified on the slide for you. I'm not going to elaborate on each of these principles, but I would direct you to pages 7 through 18 of our full submission, where I do provide an overview of the principles, their significance, and their relevance to this license. So we took these principles and we sought to identify if they were included in the CSA standards, which are now incorporated by reference in the proposed Chalk River license. And our goal was simple. We just wanted to evaluate whether A, these principles were enforceable, or B, whether they formed the basis for license and compliance and verification. What we found was that the majority of the principles were either absent from the CSA standard, or if they were included, they lacked a measurable benchmark for enforcing compliance. This was the case for the principles of waste minimization and prevention, environmental protection and sustainability, and proximity. For the principles of record keeping and waste characterization, we actually found something different. We found that while they may be in the CSA standard, they were referenced as guidance documents and not in the compliance verification portions of the license. We also found there was some legislative gaps as well, so irrespective of the CSA standards. We found that because CNL's application covers a host of facilities and activities, their treatment under the Nuclear Safety Control Act isn't the same for each of the facilities and each of the activities. So there were differentiations we found based on that, which we addressed in our report. And based on our findings, we made a series of recommendations to the Commission with the view that these waste management principles that we identified should be incorporated into the basis for licensing. And I'm not going to read out our recommendations to you, but I just will note that they are included in our PowerPoint and in our submission. Thank you.
Thank you. with respect to the waste management part of our review, so in preparing for our review, we looked at a number of documents, certainly the CMD's Performance Review Report from 2013, the Preliminary Decommissioning Report, and we identified what we thought were the three key questions to guide our review. That first question was, has ACL provided adequate information with respect to waste management, primarily in their application to renew their operating license? And we looked for guidance at the General Nuclear Safety and Control Regulation requirement, and it sets out, we think, quite clearly that the application for the license is to contain information describing volume, quantity, characteristics, and so on of radioactive waste to be generated, stored, managed, processed at the facility during its license period. So we looked at, reasonably enough, CNL's application. A brief exercise, and my summary will be brief. It did not include that information. At best, in attachment B, it included a set of references to documents they provide to the CNSC, and those documents may include that information. There's no way for us to ascertain that. But I think the question is, did they meet the requirement of the regulation? They did not. It is not included in their application. And that alone should be a stop sign for the Commission in terms of approving this application. The second question that we asked was, are CNL's practices of accepting additional radioactive waste from external sources exacerbating the waste management challenges at the Chalk River Laboratory? There's no dispute that there are large challenges in managing the waste already on site at Chalk River, and there's no dispute that part of CNL's practices are to continue to import waste to their site from other operations, and they acknowledge that in their application. We looked at the documents they provided for any additional information, and there were several very general references to the fact that they do accept waste from third parties. We looked at the full suite of regulatory oversight reports that have been much referenced in these last 3 days. And we found in the regulatory oversight report on uranium and nuclear substances processing a few references, and in our overall review of that report, where we had some interaction with the licensees, we learned that SRB and Nordion do send their waste to Chalk River. We assume that others, Best Theratronics for one, also do, but there was no information available, and the licensee did not provide information claiming proprietary interests. And we ascertained from an application to the NRC some time ago that Cameco potentially sends waste to Chalk River because there is a single application that named 9 consignees, including one in our region, Cameco's Blind River facility, and we have not yet been able to determine that there's any controls beyond the NRC application process, which says waste is coming into the U.S. from 9 consignees and will be returned back to those non-consignees. We then looked at ATOMS, the U.S. NRC's online public registry, and it's quite a useful tool, voluminous, a little bit hard to handle initially, but voluminous. And we found there, we looked at over 1,000 documents online, we downloaded 238, and from them we were able to determine that there were numerous shipments of radioactive material. I think the HEU shipments was the most contested and most documented item on the registry, but in addition, numerous waste shipments, things like uranium-contaminated zirconium, tritium gas, stainless steel, a number of different shipments of radioactive contaminated metals, medical waste, mixed waste, contaminated waste, hospital waste, from a whole variety of facilities, which you can see identified on the map on the screen. It did seem the majority of cases were returning materials sent from Canada to the U.S. For processing, but there seems to be no overall tracking system. There's no identifiable system in place for tracking these wastes. There seems to be, the third question was with respect to, is CNL making adequate progress in addressing the legacy waste and liabilities on the site? There was very little information, and I'm running out of time, so I'm going to go very quickly. Very little information provided in the CNL documents on what we identified as 3 key challenges, dealing with the tiles, dealing with the fist, and dealing with the plumes. What really was lacking was any clear sense of urgency, any milestones, any progress report in meeting those milestones. We've had some discussion. We've heard what was stated in the report, repeated here, a little bit added to it. But in our view, there's real need for those milestones and a real need for a third-party overview of that. That's lacking. Not only is detail lacking, but any kind of sense of timelines and so on. We made a number of recommendations, as Carrie has already referenced. In conclusion, with 35 seconds left, we do urge the Commission to deny the application. We recognize they can't operate without a license, so maybe it's a very short-term delay while they meet the most immediate needs, for example, meeting the regulatory requirements in including a description of the waste. Should be easily done. But they really should be limited to a 1 or 2 year application term. We had recommended a 1-year term. We would not cry foul at 2 or 3 years. We've heard many references throughout the last 3 days to these annual reports. Initially, we thought, is this the performance report? The last one we've seen was 2013. We slowly, puzzled through and concluded it's the regulatory oversight reports. Ms. Tadros, I think, clarified that yesterday with her reference to the December 2017 Commission meeting in Port Hope. That looked at 2 regulatory oversight reports that Northwatch had reviewed and commented on. Neither of those included information about the Chalk River site. We reviewed last night the full suite of regulatory oversight reports from the last 3 years. We find no information, substantive information, on the Chalk River site. There is not an opportunity in the review of the regulatory oversight reports to engage with the Commission. There are very summary reports on the information that was provided. And I'll just finish by saying our experience, reminding you of our experience with the Blind River license, the uranium refinery license, went from 2 years to 5 years to 10 years. We're at the 5-year, last year we were at the 5-year mark. In the 5-year license, there was a midterm performance report, which was substantive. So last year, seeing we were at the 5-year, I requested the midterm performance report and was referred to the regulatory oversight report, which had the standard half dozen to a dozen pages describing the Blind River facility operations. In no way a replacement for the midterm performance reports we had under 5-year licenses. In no way a replacement for a license review. So with that, I apologize for going slightly over time. So much to say, so little time. Thank you.
Oh, you're going to have a
Welcome
lot more
questions.
chance to say.
Okay, good.
Okay, I think you lined up some pretty interesting issues. So who wants to get going? Dr. Demeter.
I'll just change course a little bit. Throughout our hearings to date, we've heard very little interveners' thoughts on emergency procedures and emergency preparedness. And in your written CMD, you've brought it up twice as a collection. Do you have any comments, observations on emergency preparedness related to this site?
Brennain Lloyd, for the record, I'll make a brief comment and pass it to Carrie to see if she has something to add. My concern with the Chalk River site and emergency planning that we might see a reduction in emergency measures with the shutdown of the NRU. We saw that with Gentil, and we were very concerned about that. So in our view, as long as there is a hazard on site, the emergency planning should remain full tilt. And shutting down the NRU should not result in a reduction of emergency planning and emergency response measures. I'm going to hand it over to Carrie for any additional comments.
Thank you, Member Seeley. To that, I would just add the scope of our review was nearly exclusively on waste management, as we did propose in our participant funding application, and so emergency planning wasn't a focus. But for further resources, I would direct you to the CELA website or the Northwatch website. The CELA website, cela.ca, has a publication page and an emergency planning subsection where all of our recommendations on emergency preparedness, as recent as a few months ago, are posted.
But we do have the Office of the Fire Marshal online, and it's a good opportunity, at least for this, I think, the first time in our proceeding that they'll explain to us the new and improved PNERP, which is a Provincial Nuclear Emergency Plan.
If I could add, President Binder, I would refer you, CELA did do a substantive submission at the license extension hearing. I would also encourage you, if we're going to hear now from an unscheduled intervener on this, that we have the opportunity to bring Teresa McClellan, the Executive Director of CELA.
No, we're making
online.
reference specifically to your observation on emergency and the fact the NIU is going down. So it's good time for us to know what the impact on emergency plan is. We have not only the Ontario, but we have also the Quebec Security Public, EC, and we can hear from both sides about any remaining emergency plan concern. So can we start with Office of the Fire Marshal? I understand it's Mr. Nodwell.
Correct. Good morning, Dave Nodwell here.
Go ahead, please.
Okay, thank you, and good morning. Dave Nodwell, I'm a Deputy Chief with the Office of the Fire Marshal and Emergency Management, for the record. So perhaps what I may do, President Binder, is provide an update on the work that's being done related to the Provincial Nuclear Emergency Response Plan, and then go into more specific detail in terms of the implementing plan for the Chalk River site. So on that basis, there has been a significant amount of work that has been done over the past couple of years related to the Provincial Nuclear Emergency Response Plan. For those not familiar with that, I'll be referring to it as the PNERP from this point forward. This started with the development of a planning basis discussion paper. So taking a new look at an assessment of the risk and the hazard. That particular document, in addition to proposed changes to the PNERP, was publicly posted for public consultation in the late spring, early summer of 2017. During that 60-day period, we had a tremendous response. We had approximately 1,600 submissions that were submitted related to that, and certainly a wide variety of opinions and perspectives. An independent advisory group was formed to address all of those submissions. So this was a group of people with a variety of expertise, from nuclear to emergency management, and it also had some international representation on the committee. So it was as objective as possible. And this advisory group was tasked with reviewing the submissions and making recommendations to the minister. The advisory group met towards the end of August, the 21st to the 25th specifically, but did a lot of work subsequent to that in order to deliver the report to the minister. It was delivered in September and was received, and the recommendations were agreed to. Based on that direction that we received from the minister, the PNERP master plan was updated and was approved by Cabinet towards the end of December in 2017. At this point in time, for those familiar with the PNERP, we have 7 implementing plans, which we are currently working on. The primary focus right now is on some of the larger power reactors, Bruce and Pickering in particular. There is a specific implementing plan for Chalk River, and that will need to be assessed, and I think I may address the comment that was made earlier with respect to concern about reduced emergency measures with the NRU being shut down. Once the NRU is shut down, there will have to be an assessment of the risk that is posed by, well, what remains, quite frankly. I think it's important that that emergency plans and emergency measures be appropriate to the actual risk. Once that risk assessment has been complete, it would be reviewed with stakeholders, including CNSC staff, Health Canada, Ministry of Health and Long-Term Care, and other stakeholders that are involved in nuclear planning in the province. That recommendation would be made to the Deputy Minister and ultimately the Minister with respect to planning that would go forward for the Chalk River site. To put it into perspective, of course, the primary focus of the implementing plan is on the NRU. And there was a very detailed assessment done in 2004, 2005, an independent study of the area, and concluded that in a severe accident arising from the NRU, sheltering would not be required beyond 8 kilometers, evacuation not beyond 3 kilometers, and KI not beyond 1. There was a subsequent analysis done which basically confirmed and validated that information. Nonetheless, despite that, the decision was made some time ago that the primary zone for Chalk River, or the detailed planning zone as it's known now, would be in fact 9 kilometers. One of the unique differences with this site, as well, I would point out, is that the exclusion zone is significantly larger at Chalk River. It's approximately 6 kilometers that is within the site boundary. If we contrast that to a power reactor in Ontario, where it is generally at about 1 kilometer. So we would do that risk assessment. Now, whether that leads towards a specific implementing plan for Chalk River or not, I can't speak to that. That would depend on the risk assessment. However, there is another implementing plan, which is called the Other Radiological Plan. And that implementing plan deals with all other radiological or nuclear potential issues. It deals with sites such as the McMaster Research Reactor, the reactor at the Royal Military College. It deals with transportation issues, facilities like Cameco, so on and so forth. So based on that risk assessment, it is a possibility that we would look at moving that to the Other Radiological Plan. But again, I'm speculating on that because it really boils down to a risk assessment. So that provides an overview, I think, of where we are, where we're going with the PNERP. I'd certainly be open to address any other questions that you may have.
So thank you for this overview, very useful. Now I'd like to hear from Mr. Lessard. Est-ce qu'il y a des commentaires?
Gaétan Lessard, directeur régional de la sécurité civile pour la région de l'Outaouais. Non, je confirme que la position du Québec par rapport au plan de mesures d'urgence s'aligne beaucoup avec la position de l'Ontario. C'est-à-dire que notre plan de mesures d'urgence va rester, va demeurer effectif tant et aussi longtemps qu'il n'y aura pas une nouvelle analyse de risque qui va être produite après le déclassement. Et notre tendance est aussi à s'aligner vers un plan qui ne sera peut-être pas de mesures d'urgence nucléaire, mais radiologique, considérant que les plans sont souvent basés sur le pire scénario possible. Le pire scénario possible actuel était en lien avec le réacteur NRU. Donc, le nouveau pire scénario possible sera peut-être plutôt en lien avec un incendie sur le site ou le transport de matières dangereuses.
Well, merci beaucoup. Anybody question to, at least while we got the Office of the Fire Marshal online, any further? I think that was pretty comprehensive. Anybody wants to, you want to make comment on that?
Yes, please, Dr. Binder. Brennain Lloyd for the record. So I just want to note to the Commission that the PNERD came out December 22nd, 11 days after our submission deadline. So I have not looked at it yet. I believe that at least Ms. McClanahan at CELA has, so I would hope that you would consider some additional comments from us specific to this, given these developments. And
Just for clarity, he's not an intervener. He was invited by staff to actually comment on some of the stuff here. You will have ample opportunity to deal with Office of the Fire Marshal in all kind of hearing coming up.
so for the purpose of this comment, just substitute intervener for invitee. And I would just encourage the Commission to ensure that, and I think it's within your abilities to do this, to ensure that your regular stakeholders, public interest interveners like Northwatch, like the Canadian Environmental Law Association, like the Indigenous organizations, are included in that review of the NRU risk analysis when it comes to that time.
I think PNERP already said that they are going to review whether the PNERP is there, is the provincial. So they'll have to do the review, but I'm sure our staff will be watching it. Maybe you should add a question, how are you going to interact with PNERP if it's going to be modified?
Haiti Tatters for the record. So yes, once a risk assessment by CNL has been conducted, once the NRU shuts down, CNSC staff obviously do get involved and review it. I would ask Mr. Richard Tennant to speak to sort of the linkages we have with the Ontario Fire Marshal's Office and the Quebec Agency for Security of the Public.
Richard Tennant for the record, Emergency Management Preparedness Programs. As I stated yesterday, CNL's program is currently in compliance and continues to be in compliance. When NRU shuts down and defuels, as Mr. Nodwell stated from the province of Ontario, that within the master plan there is a section 1.45, which clearly states once the reactor facility has been shut down and defueled, an assessment shall be undertaken by the province in cooperation with additional authorities having jurisdiction to determine the risks it may represent to the surrounding off-site population. If it is determined that the reactor's new status poses no off-site hazard, this PNERP shall no longer apply to events originating from this reactor. So any authority having jurisdiction will be involved in that assessment. It's ultimately the OFMEM's jurisdiction, So they can invite other people if they would like, but as Mr. Nodwell mentioned, CNSC, OFMEM, Circuit de Quebec, and any other stakeholders. And with respect to continuing emergency measures at the site, even if NRU does close down, the CNSC will impose its requirements through Regulatory Document 2.10.1, so emergency measures will continue to be exercised at CNL.
Okay, thank you. I think we got other issues to deal with. So, question, who wants to start? Dr. Solomon?
My question is concerning recommendation number 8. And the question, I would like the answer by the staff about the lack of some of the information given in CNL radioactive and waste hazard material. The submission is supposed to include the volume, origin, form, quantity, and name of any radioactive waste. I would like you to say if the information exists in some other documentation, highlight this documentation, please.
Haiti Tatters for the record. Thank you for the position in the question. So I would ask Mr. Nan Tran to outline what was in CNL's application with regards to the information in Recommendation 8, and specifically if there are any other documents that this information was found in.
My name is Nan Tran, for the record. I'm a Senior Project Officer with the Nuclear Labs and Research Reactors Division. The intervener pointed out that in Section 3 of the general regulations, it describes a number of things for general license application requirements. Section 7 of the same regulation allows incorporation by reference for license renewal applications where information has already been submitted as part of a valid license. So in the case of CNL, CRL, they already have a valid license, so what they did was they referenced the information that's already been submitted to staff as opposed to resubmitting all that information. Section 5 of the same regulation actually asks them to identify what's different between the information we already have and the information needed to support the application. So I think some of this confusion is probably around the understanding of what they actually needed to submit. All that said, the specific information in Recommendation 8 is submitted to staff, and it's available through the existing programs of the management system, and specifically the ones related to waste management and decommissioning. I'll pass the question to Corinne Glenn, the Director of the Waste and Decommissioning Division in Ottawa, and she can speak a little bit more to it.
Can you please, Ottawa, could you please elaborate on the statement that the 5 principles of the IEA are not being complied with?
Corinne Glenn, for the record. I am the Director of the Waste and Decommissioning Division at the CNSC. I'll begin first by addressing the comment regarding that there is no list of the waste that are currently at Chalk River. Every 3 years, as part of Canada's commitment as a signatory to the Joint Convention for the Safety of Used Nuclear Fuel and the Safe Management of Radioactive Waste Management, Canada is required to assemble an inventory of all waste that it currently manages, and that inventory is assembled by NRCan, and it is published in Canada's report to the Joint Convention, which is publicly available on the CNSC website. I mentioned yesterday the latest version was submitted to the IEA in October of 2017. Right now, the full report is not available on the CNSC website. It is pending translation, but there is a summary, and if the intervener is interested in receiving the latest copy, as I mentioned at the December Commission meeting, we are happy to provide anybody who requests a copy of that report. I'll address your second question, Mr. Binder, which I believe is related to the incorporation of the GSR Part 5 principles, specifically referenced in the intervener's written submission. I believe we touched a little bit about this on some of the other days, and specifically some of those principles refer to the requirement for a management system for waste management, the requirements for demonstration of environmental protection, for the licensee to submit a safety case. And those are captured through other provisions of the license specifically or through provisions of the license application. And we discussed, I believe, on the first day of the hearing that if we were to put for every single safety and control area management systems and environmental protection and radiation protection for every safety and control area and every single program, we would essentially be repeating all 14 safety control areas. The requirement, for instance, for the licensee to have a management system that applies to waste management is captured by the corporate management systems program, which covers all of the activities that the licensee carries out of the site. And therefore, there's not a specific need under the waste management area of the license or the license conditions handbook to have that specific requirement. That being said, in the CSA standards, a requirement for a management system is captured in the N292 suite. And that is definitely captured through the reference in the LCH to the N292 waste standards. And to touch on another one of the interveners' recommendations, which is to incorporate N292.0, which is the overarching standard, while it is incorporated through reference in the other standards, we are taking that comment into consideration and we'll look at that as we revise the LCH in order to make that clear.
One more thing which I think needs to be addressed in the same vein. There is, I think, an argument, and I'll let the intervener, if I get it wrong, that some of those CSA standards are not enforceable. And, you know, they give an example of the minimization, environmental protection, and proximity. Can you address some of those aspects?
Corinne Glenn, for the record, absolutely. CSA N292.3, which is a CVC in the proposed license condition handbook right now, incorporates immediately the requirements of N292.0, which I'll read out to you, which it clearly states, in addition to the requirements provided in the standard that are specific to low and intermediate waste, the requirements of CSA N292.0 shall also apply where applicable. And then if I go to the CSA N292.0 standard, there is a section that particularly deals with operating practices for minimization and segregation. That's found under section 5.20 of the CSA N292.0, and it states the following: to minimize the generation of radioactive waste, the following operating practices should be considered: redistribution of unused materials and sealed sources, the use of items that can be laundered or decontaminated for reuse, minimizing the use of absorbent materials, the use of dedicated areas to avoid cross-contamination, identification and separation of incompatible materials, monitoring to minimize the spread of contamination, and monitoring to ensure that waste not in compliance with clearance levels is identified. That's just one example. The other ones, you mentioned this proximity. Proximity, in the terms of proximity principle, as the intervener outlined in her written submission, is not an IAEA principle that is found in the GSR requirements and not found in the CSA standards. It's more important from a safety perspective to find a suitable location for waste management and storage that meets the safety requirements for the long-term safety of that facility than it is to find one that may be close or, if you'd like, immediately adjacent to the facility. In many cases, that is the case because when we cite large facilities such as a nuclear power plant, we take into consideration seismicity, the suitability, many other hazards that would also apply to a waste management facility. But that's not directly a requirement either in the IAEA regulations or guidance, I should say, or in the CSA standards or the CNSC regulatory documents. It is up to the licensee to propose the location of those activities and to provide justification through a safety case that that location is suitable for those activities.
Okay, thank you. Question?
If I may respond to that?
You'll get your chance. I've got a couple of questions, then you can go through one by one. Mr. Silly?
Yes, I had a question for staff. One of the recurring themes has been about the license condition handbook, clarity and assurance that we have enough requirements in there to understand the compliance requirements for the licensee. And I just wanted to then go to one of the recommendations by Northwatch and CELA, recommendation number 6 on page 9, which talks about the environmental management or environmental protection section. And their point here is around environmental protection, of course, is important for waste management components as well, and recommending that Reg Doc 2.9.1, which is referenced here as a verification criteria, but it's only referenced for one section, 4.6. And I think your point is, why isn't the whole document referenced as a verification criteria? And maybe just one other piece of information on that. In the previous license, the verification criteria did include the whole document, 2.9.1, and it also included ISO 14001 standards. So I guess my question is to staff, all of a sudden you've gone from two very large, pieces of information that would provide guidance to only one subsection of one of the CNSC's regulatory documents.
Mike Rinker for the record. So I think what's important is to look at the year for the version of those documents. The old license had regulatory document 2.9.1 published in 2013. And this document was substantially updated in 2017 and included many more elements. So the 2.9.1 version 2.3 is entirely contained within section 4.3 of the new version. What was added in 2017 was the overarching and complete regulatory framework for environmental protection. And it included, for Class 1 facilities, setting out our framework based on a series of CSA standards. So by having a licensee implement the CSA standards that make up our regulatory framework, they are in fact compliant with regulatory document 2.9.1, the most current version, with the additional requirement of having an environmental management system, which is the section 4.3 as noted. Sorry, 4.6 is noted. I think it's also important.
One of my questions, so Reg Doc 2.9.1 is a CNSC document, is it not?
Mike Rinker for the record. It is a CNSC document, and it sets our framework in the early sections of that document that the CSA standards form our basis. So that is set in our regulatory document, and when we consulted on that document, we brought that document to the Commission for approval, and it set out that our regulatory framework is based on a series of CSA standards plus other elements. I think it's also important to note that this document contains the two processes for which CNSC staff would follow for an EA conducted under the Canadian Environmental Assessment Act. This is not something that a licensee could implement. It sets out the process that CNSC staff would follow for an EA under the Nuclear and Safety Control Act. So these are not things that a licensee would ever implement. What they would implement is an environmental management system as described in section 4.6, and they would also implement an effluent monitoring program, an environmental monitoring program, an environmental risk assessment program, and a groundwater monitoring program, which are as set out in that reg doc to follow under the CSA standards.
Sheila, do you have something to
Yeah,
add
if I
here?
may respond to that. Thank you, Member Seeley. This is Carrie Blaze for the record. I'll respond to the questions in reverse. I'll respond to the last question first while it's still fresh. I respect your comment that in the proposed license condition handbook, it was the pinpoint to section 4.6 that struck me as being different in this LCH compared to the prior one. And I still don't understand the rationale for having a pinpoint when there is a framework in the reg doc which would be applicable to the licensee. And I'll point to section 2 of the reg doc. And again, I can pull it up very easily on my phone. It's on the CNSC website, so I appreciate that. I couldn't do that with a CSA standard as quickly. But with this reg doc, I can pull it up very quickly. And section 2 is the environmental protection principles, which does encompass much of what I discuss in our submission around this principled approach to waste management. So ideally, pinpoint to section 2 would be included in the license condition handbook too. And because section 1 is the intro, which introduces the purpose of principles that should inform environmental and waste management, I think it's helpful that the licensee be held to the standard in the entire document. So to have a pinpoint is redundant. So I would support that the pinpoint be removed, the reg doc remain in the license condition handbook. Regarding the question I was asked before regarding the 5 principles that I reviewed, I'd just like to clarify that these were principles that weren't just informed by a review of IAEA standards. It went beyond that. I looked at different licenses, nuclear facility licenses from the UK, in Scotland, any document that would talk, even literature about principles for waste management. So, and these were 5 groups that I came up with, and I sought to understand how they were included in CSA documents. And while I appreciate the response from CNSC staff regarding that perhaps these principles are in the licensing condition handbook, they are in, to the extent they are there, they would be referenced in N292.0. And again, this is a guidance document in the license condition handbook. So there is a conflict. If the license condition handbook lists a standard as guidance, but then a compliance document says, no, that guidance is a standard, there's just an unnecessary conflict, which can be easily resolved if N292.0 is just moved into the compliance section. And then there won't have to be any discussions about, is it guidance, is it compliance, and how to read many documents in tandem. I would also just reiterate the findings of my submission that while the word environmental protection might be present in the CSA standards, it doesn't deal with how to deal with it, what the details should be to accomplish an adequate protection of the environment plan for waste management. So again, I just found these standards lacking for helping the licensee to find that threshold so that compliance can be enforced against that benchmark. Thank you.
Jean Leclerc for the record. I think it's worthwhile to provide some further clarifications. In the supplemental CMD, in fact, we speak specifically to Northwatch's intervention with regards to the 292.0 that's in the guidance. And in our notes, we said we can certainly address that to provide further clarity. but I do want to clearly highlight that when a standard that's been referenced in compliance verification criteria refers to part of another document, by reference, it becomes a requirement. So when a requirement says, here are all the things that are going to apply, as well as section XYZ of another document, by reference, it becomes a requirement. However, that being said, I think I appreciate the intervention, and I think it's worth providing that clarity in the LCH so that we avoid any confusion. And so therefore, we accept that recommendation of bringing forward 292 into the requirements so that we avoid that confusion. I want to then touch a little bit further on, there seems to be a continuing misunderstanding on the structure of the License Conditions Handbook. We keep hearing about environmental protection. There's an entire section of the License Conditions Handbook that's dedicated to environmental protection. The fact that the waste management section doesn't necessarily talk explicitly about environmental protection doesn't mean it doesn't apply. There's an entire safety control area that speaks specifically to environmental protection. And the reason why that's done is because we want environmental protection to apply to all activities that are being done at the site. So I'd like to perhaps ask Mr. Nantran if again he perhaps can go through the structure of the License Conditions Handbook to make sure that we really reiterate and reemphasize what Mrs. Glenn has mentioned, what I've already mentioned previously, that we don't repeat. If we have a thing that says management system, for example, which is the first safety control area, it applies to all their activities and facilities.
I think we got it. For the last 2.5 days, we've heard about that. So I don't think there may be disagreement about the structure, but I think we know what the sides are. I'd like to move on to other questions, though. There's some other questions. Dr. McEwen.
So can I move back up to a very high level? Because I really want to understand sort of more globally your concerns. If I listen to your submission and read your report, in terms of waste, you appear to address maybe 4 different groupings of waste. There is the legacy waste. There is ongoing waste production. There is waste related to the decommissioning of the NRU. And then there is, if I could call it, future waste from ongoing operations, from operations both internal and external. Have I understood correctly that that is your concern? And are any areas of those more or less important as you try and look for the inventory, as you try and look for the handling, and as you try and look for the planning for the future?
Brennain Lloyd for the record. I think that, no. I don't think that there's one of those waste baskets which we would set aside in exchange for more attention to the other. I don't think that's exactly what you were suggesting, but I think they're all important. I don't think at this point, Northwatch would certainly not claim to have a comprehensive understanding of the waste hazard at the Chalk River site, legacy, future and ongoing. And that causes, that's a cause for concern that we don't, I don't think that as the public, I don't think we have reasonable or ready access to that information set. And so I think that, certainly each part of what we presented, included in our submission and have presented today, is only part of the picture. And that's simply, constraints on our own capacity and technical reach at this point in time. But I think that these are problems or sets of concerns that are single and cumulative. And I think that I appreciate the encouragement to look at the Joint Convention for additional information. I did look look at the summary after it was mentioned in the December meeting. I certainly didn't find anything that would satisfy our interest in having an inventory of radiological hazards related to waste on site at Chalk River in that document. I have read them pretty religiously over the last number of years when they, as they become available, and I do know that they are one of our few remaining sources of information about radioactive waste giving us a national picture. We did have in earlier years other inventories that we relied on, which have not been replicated in recent years. And I didn't go back and read it again, read the 3-year-old version to see, and I'm now this morning kind of regretting that I didn't, but I will. But I think that we need to start with an inventory. Then we need to have an understanding of the hazard. We need to know what the, what is the program, both in delivery and intentions, for each of those waste streams, and then we need milestones to measure how we're making progress, using the word we very generally, making progress towards those milestones. Our concern is that waste continues to be generated, waste continues to be received at the Chalk River site when there is not grounds for confidence that the waste already on site is being managed in the most effective way means possible. Even that, and I think that's why we looked at those 3 areas within the legacy program to just test and see what information is available. I think the license application is a reasonable place for the public to be able to find information on how's the licensee doing, and it's not there.
Okay, so I like to go from high level to the roots. You mentioned the legacy, and you mentioned the tiles, the fist, etc. So where are they? Maybe we should start with CNL. What information are available on progress of dealing? Because I thought I heard some detailed plan for the future about how to deal with those items. Maybe I'm wrong. Please clarify.
So Dave Cox, for the record, I'll ask Kurt Keeler to elaborate on some of those dimensions of our waste management and remediation activities, but I'd like to first start by saying that we have a very comprehensive waste management program which collects and generates accurate records as we're required to meet all of our international commitments for nuclear material inventory, whether it's waste or other materials. It's very accurately characterized and cataloged. It's part of our program, and so we maintain this kind of information. It's one of our fundamentals. But in terms of the program and where we're going with it, I'll ask Kurt to elaborate.
Kurt Keeler for the record. It's a very broad question, so I'll try to touch on a few details, because obviously we have lots of different types of waste in safe storage, and we continue to keep those in safe storage. Key to our program is development of the integrated waste strategy, as you've seen referred to in several cases. That is available on our website in a summary form. The integrated waste strategy actually looks at every different type of waste that exists on site, with the goal to come up ways to permanently dispose of that waste. Obviously, disposal of waste is a very big issue, and any of those decisions will come back as a separate issue to the Commission, when we come forward with those proposals, just like with the near-surface disposal facility for low-level waste. We previously mentioned for FIST that was part of the repatriation project, and that project is on schedule and continuing. It's about somewhere around 20% complete. That FIST will continue till it is scheduled to be complete in 2020. For the HEU, which is just one portion of the spent fuel on site, which is can be repatriated under the Global Threat Reduction Initiative. That work is ongoing. It's about 50% complete, and that's scheduled to be completed in 2019. We do store various forms of intermediate level waste, of mixed waste on site. We keep those safely stored, and for many of those streams, we are currently working with science and technology, doing work to determine the path forward for those streams. For example, the cemented moly waste is a very large stream of waste stored on site that is an output from making moly for all the decades there. There is not a path yet determined for that particular waste stream, and we could go through a number of different types of waste and get into some detailed discussions on each of exactly where we're at in science and trying to come up with solutions.
I think the intervener probably knows that you know the question was how much of this information and the program and the milestone against those programs are in the public domain. I think that's what the question is.
That level of granularity, I would admit, is probably not easily available in the public domain. It's a significant program of work covering all kinds of different waste forms. Some of it is covered. Plans for low-level waste are obviously being openly debated quite fervently at this point in time.
But I'm talking about tiles and plumes and things of that nature. Will they be annual? You know, I know the intervener doesn't think much about the ROR. I think staff likes to beg the difference. But will progress be made in the annual regulatory oversight reports, or could be made?
We cover some of the current activities and conditions of those streams under the annual safety report that is issued. So it does provide some of the information. It depends on the level of detail that everybody is looking for.
If I could add something here, Dr. Binder. Sean Cottenham, Chief Regulatory Officer. I get the question, looking for specific details. I think that's a fair point. I've been in the Environmental Stewardship Council when Mr. Keeler does give verbal updates on many of these. We also have slides decks that go with that. If I could point to our CMD, there is some information that we provided, and I could give a few references here if you want to go through them. I have them earmarked here as well. And of course, in our opening presentation, we did give updates, but many of these are written in progress on our NRX plume. We've talked about, we're very proud of the project, the FPS commissioning and project as well. The FIST for security reasons, we all know that. We give a % complete. Mr. Keeler did that already in the first couple of days, but I have some references we can walk through if you'd like.
I'll leave it up to the interveners.
Yeah, if I could just comment, this is all interesting information, and I will read the transcript and retain more than I'm retaining at this exact moment. But, you know, just let's look at the tiles for a moment. When we look at the summary of the CMDs, CNSC staff provided a, you know, maybe I would say a 200-word summary compared to CNL's maybe 30-word summary. I think that we should be seeing more from CNL in their documentation on this. We did request some documents. I would need to hand it over to Ms. Blaze to get a check on which documents CNL refused us, but we were refused some documents. Looking at the tiles, as an example, we heard yesterday that the tiles are halfway through the retrieval process. Why are we halfway through the retrieval process? What was the milestone set for this? In CNSC's, in staff CMD, they do describe the, you know, the packaging plants, the fuel packaging and storage facilities designed and constructed. Why are we halfway? When will we be all the way? What's the, you know, what's the lessons learned in the program so far, and where is it going to go, and what can we expect in terms of progress? That's the kind of analysis and information that we would like to see. Mr. Binder, you may have been right in your perception that I don't think much of the regulatory oversight report.
You just said that.
I would like to think more of them. I'd like to think very highly of them. And I think that there's lots of opportunity for them to be improved and expanded. What I've seen so far has not satisfied our information interests, and specific to Chalk River, I haven't found Chalk River in any of them.
Well, just to
could have-
clarify, Chalk River, did they have ROR, or is it sort of new? When was the last report on progress with Chalk River?
Haiti Tadros for the record. So we looked it up. The last time the Chalk River Laboratories site was referenced in our ROR was in 2014. Since then, we have been in 2 licensing proceedings, one in 2016, which gave an overview of all of the programs in order to set the licensing basis at that time. And we are here today, 2 years later, with the performance of all the programs to set yet again the licensing basis for the next proposed term.
But moving forward, if a license will be granted, there will be an annual ROR. Is that what it is?
That is correct. Moving forward, with the opportunities that we do have a regulatory oversight report that deals with research facilities, which Chalk River would be in that category, we would put all of those facilities together and bring the Chalk River Laboratories facility forward as a regulatory oversight report with safety performance information in there.
So if Brennain Lloyd, for the record, if I could understand then, I think the last regulatory oversight for nuclear processing, small research reactor, and Class 1B accelerator facilities was 2015. Is it that ROR that would be augmented to include? So, and I have commented, I think, to the Commission before, perhaps only in writing, that I would find it really helpful to have a table of the regulatory oversight reports. Every year, it's a different combination of topics seems to be addressed in different regulatory oversight reports. So, and they're not all in one place on the website. So if we are going to be relying on a new, expanded, improved, substantive, in-depth, detailed set of regulatory oversight reports, then it would be helpful to have them all in one place in a table saying what we can see where. One final response, the Stewardship Council was mentioned as a place where Kurt provides summary reports or overview reports. It's my understanding that the Stewardship Committee meetings are not open to non-members, and Northwatch is not a member. I wonder if we could hear from CNL if those Stewardship Committee meetings are going to be open in the public, open in the future. If that's where we're to look for the information that we consider
At least I
important.
assume that the slide presentation you made over there should be posted on you, at least, I assume.
Is that yes to the meetings being open or to the slides being posted?
Pat Quinn will comment on that.
Hello, Pat Quinn for the record. Proceedings of our Environmental Stewardship Council and information and presentation material are available on our website. The Environmental Stewardship Council is actually, it is facilitated by a third party, and so we have terms of reference that are available on the website for review, and people can make requests through our third party to observe that type of thing, but basically there's a membership process and it's managed through the third party. But we do put our meeting notes. They are not minutes or a transcript. We do make the meeting notes and the presentation material available on our website.
Okay. Question? Go ahead.
So listening to all this, I was thinking of what would help us and interveners and everyone else understand better the issue of the legacy waste. Is that there was a slide on CNSC's presentation 39, which showed the operating performance NRU shutdown timeline. And that kind of graphic is really helpful for us to understand not only the components of managing that, but the timelines. So for all the major legacy issues, if a similar graph could go in, what are you doing with FIST? What are you doing with soil? That would be really helpful because it encapsulates timelines and major activities related to that process. And just a comment that I really found that helpful, and it might be helpful for other major issues.
This is the famous cigar slide from CNSC, and one there.
So, Jean-Luc Lau, for the record, a couple things I want to clarify. The question as to when was the last regulatory oversight report, I have to remind people that the introduction of annual regulatory oversight reports was associated with 10-year licenses. So we haven't had, there is no 10-year license. We're waiting to see what the decision the Commission will make. But I think it's important that we clarify that. So stating when was the last annual report, well, the reality is those reports were done under the different structure of the way the license was. I think Ms. Tadros mentioned that we've been in license renewal hearings now. In effect, there was a license renewal hearing in 2016, and then it wasn't that long after that we kicked into another license renewal hearing. When we do license renewal hearings, we don't do regulatory oversight reports because we capture performance through the licensing hearing. I just want to put that on the record so that it's clear. The other thing I want to emphasize is the regulatory oversight report actually has a section that's dedicated to identify changes that have occurred. The purpose of the regulatory oversight report is, in fact, to say, here's the performance in 3 key areas: radiation protection, environmental protection, and conventional safety, which ultimately are key indicators of what matters: protection of people, the public, and the environment. The other part is we also, in the report, identify changes. That's part of the report. We recognize that the Chalk River site, the environmental remediation and these activities that are doing are definitely changes that are going to be happening. So it's quite clear you can expect that in the regulatory oversight report, in the section that talks about the changes that have occurred over the last year, that this information will be provided. I do want to comment that I do appreciate the Northwatch intervention because it did highlight a number of things, and there's certainly things that we can consider with regards to how to make the information clearer. Historic data, for example, doesn't necessarily have to be reported all the time. It's historic. There is so much volume of waste. It's been there, and it's been there for many, many years. We tend to focus on deltas, but we certainly take that information under consideration, and we can see how we can incorporate that both in the licensee's annual safety review reports and the ROR.
But I think the suggestion from Dr. Demeter about using the slide, this is a general comment. We like photo, we prefer videos, but sometimes those pictures are really in one picture. You can get a lot of information, which is really easy to absorb.
If I may respond to that briefly, Commission members. I would just like to highlight that if there is a shift to the ROR process to voice concerns and engage, I would just remind the Commission that CELA was at the regulatory oversight report for nuclear power plants in the summer, the uranium processing in mills ROR, I believe that was in November, and also the nuclear substance ROR in October. And we attended all 3 in person. I was there, but only in one instance where we given an oral presentation opportunity. So yes, we provided written comments, but I would ask that if there is a shift to RORs, that the oral presentation opportunity accompany the written submission opportunity.
It's a Commission decision, and take it under advisement. Coming back to the photo cigar, is it doable from CNL?
Dave Cox for the record. I mean, generally, I think in terms of providing more long-term information about the status of activities, it's something that could be built into. In terms of waste management specifically, I'll just ask Kurt Keeler to comment on that.
Kurt Keeler for the record. The comprehensive preliminary decommissioning plan gives general schedules for completion of the work at the site. Must be kept in mind, though, for waste management, until disposal methodologies and avenues are found, the site does storage. So even when we talk about the FPS system And 100 tile holes, that's only 100 tile holes out of thousands of tile holes we have at Chalk River, is just to restore that fuel in a different temporary storage condition. You know, it's not until there's a deep geologic repository available for the country that we stop doing interim storage. And that's the same for every type of waste stream. So when you read the CPDP, it'll make some assumptions about when disposal facilities are available, right, wrong, or indifferent.
I fully appreciate, but you know, we started this process for mines, when mines will return the land to the original thing, and it's hundreds of years, but it's still in one photo. It's a plan. It's going to change, but it's really easy to absorb. It's a communication device. It's not really the detail. And it was very useful, and I think all the mines licensees now are using end of life. What's the end of life of the project?
So the famous cigar graph actually comes from the Comprehensive Preliminary Decommissioning Plan. And so if we need to make more of those in the plan, we can do that.
And many more cigars.
Yes.
I think we're talking about Gantt charts, but we'll go with cigar for now.
Okay, one more issue that I really we need to deal with, and that is the intervener talking about importing of waste. And I thought, I don't know if you caught, we dealt with some of this. In fact, we had ACL give the government policy on what is allowed to be imported into to CNL. And obviously, CNL will not take anything they cannot handle. So I don't know if you need, I'm sure you know some of this stuff, but maybe a quick item, particularly on this known unknowns like Cameco and some other kind of a thing that you found out from the U.S. ADAM system. I don't think it's a secret, but we normally don't talk about precisely what goes into the site. So maybe we'll start with ACL, reminding everybody what the structure, the policy structure is.
Shannon Quinn for the record. On one of the other days of the hearing, I talked about the fact that in the GOCO contract structure itself, there are terms and conditions that would require CNL to come back to AECL and, depending on the nature of the issue, potentially further back into government, should it wish to change in a substantive way the volumes of waste that it's accepting from third parties, or substantially change the nature of the waste that it's accepting from third parties. So this should, it's a protection so that the Government of Canada rightly has decision-making power around sort of what is coming onto the site. The intervener was absolutely correct that CNL and previously ACL have been and will continue to accept what are relatively low volumes of waste, primarily from universities, hospitals, and, as was already referenced, various entities that are in the business of medical and other isotopes. In terms of sort of specific sort of customers, some of that would be commercially sensitive, but I will turn it over to CNL after to see to what extent they can talk to that. I'm not sure that I've really addressed sort of points around the crossing of international borders, so the transport of waste sort of between Canada and the U.S. In both directions. But I think the question of that's really at hand is what's coming in and out of CNL, and hopefully there's been some reassurance provided that there are checks and balances there under the terms and conditions of the GOCO contract.
CNL?
Kurt Keeler for the record. We do not accept waste from outside the country. But let me clarify, CNL does use commercial suppliers and vendors to manage some difficult waste streams on occasional basis. For instance, if we use metal melt, we may send metal to the States to go through that process as part of the recycling and waste minimization procedure. As with most of those, whether it would be metal melt or any other segregation type or waste minimization approach where we use a primary vendor, oftentimes we will receive that residual material back. But that is our material to begin with before it goes to the supplier to go through the waste reduction, waste minimization process. So other than those types of shipments of waste, we don't receive waste from other countries.
So normally waste, particularly nuclear waste and equipment, they require a license. So under which license are you opening? Are you opening under general import and export license, or every shipment require a different license? And maybe CNSC can help us on that one.
So transport of dangerous goods regulations apply to the shipments themselves, for packaging and transport. Import and export permits are required for international. So we're in compliance with all of those requirements.
So Haiti Tatters for the record, and I believe Ms. Glenn yesterday gave us an overview of waste transport. So I know she is online right now and willing to provide some clarifications on the transport question.
Corinne Glenn for the record. I'll speak a little bit about the instances, some of the instances mentioned in the intervener's written submission. The CNSC operates in a slightly different fashion as the Canadian regulatory framework. And when applicants in the U.S. Submit an application, they will list a number of potential sources from where they could receive the waste. So if they are a service provider which offers waste processing services such as incineration or metal melt or decontamination services, they would list many more companies in Canada, for instance, than they actually have contracts for. And that would be done in order for them to have not have to continually go back to the SNRC to add a potential source. And that doesn't necessarily translate in there being shipments of that waste from Canada to that licensee in the U.S. And so it is, as mentioned, as Mr. Keeler mentioned, an option that many licensees in Canada use is they use services of waste processing facilities in the U.S. Where the waste is processed or separated, minimized, and then the resulting waste, whether it be ashes or metal that cannot be further smelted or cleaned, would be returned to the licensee for their long-term management. We do not, at the CNSC, maintain records of all of the shipments that are made of such waste. The licensees do. And through regular compliance verification, our inspectors would verify individual, spot check those records, and if they find any irregularities, we'd delve further into it. I'm not sure if that answers some of your questions, or if you need any more specific relating to the import and export licensing.
Thank you. Over to you.
Thank you. Brennain Lloyd for the record. I've appreciated Ms. Glenn's explanations yesterday afternoon and also those from Ms. Quinn, but I think we still have a problem. I'm fairly satisfied by my review of the Adams postings that I was able to identify that it appears to be the residuals are returning to Canada. So that makes Kurt's statement that we do not accept waste from outside the country kind of, you know, mostly true, but but it doesn't. It's not incorrect, but it creates an impression that I think could get him in trouble if people took it on its own. And he sort of said it on its own and then came back to it later and said, but of course we do send waste out and get it back. That's a problem. I think that's a communication problem. I think the other problems we have in this area, I think, are around transparency and disclosure. There is a public concern about the transport, the trafficking, the export, import of waste. There is a real concern, I think, about how the Chalk River site is burdened by waste from external generators. And I think where we come down is what is really lacking is a chain of custody or quality control, quality assurance, or any evidence of that is obvious to the public. I don't see a chain of custody. And we made some of these comments in our submissions to you around the Pickering-Darlington Bruce license amendment a few months ago. But I don't see a chain of custody here. So when I appreciate Ms. Glenn's explanation that a company may want to list 9 potential consignees so they don't have to keep going back to the NRC. That, sort of broad brush, coupled with Ms. Glenn's confirming that CNSC doesn't track these shipments, is a cause for concern. I don't see where the chain of custody is. I don't see where the quality assurance, quality control is, other than I understand that there is some compliance inspections done. But I think it's really loose goose.
Okay, well, just a quick, what volume are we talking about here, maybe on an annual basis? And CNSC, how do you feel, why are you comfortable with the current situation?
Kurt Keeler for the record. I don't have the numbers of volume at my fingertips, so we can try to get those. Our largest volume that we do cross-border shipments are core for the repatriation project, because that's an ongoing concern. And so, but
I'm not talking about those who are known quantity and we measure and the CNSC measure them. I'm talking about those kind of unusual, like you talk about the metal.
right. They're not very many at all, and so we can try to come up with some numbers for that. No, it's just occasionally.
Staff?
So Haiti,
I think Mr. Jamal wanted to jump right into it.
then that trumps my answer.
Senator Jamal, for the record, we appreciate a lot Ms. Lloyd's intervention. I just do not really agree on the fact that it's loosey-goosey. There is nothing that's loosey-goosey. We are overseeing the licensee. They are licensed in order to manage their operations. The transport tracking is not done, but it does not mean it's loosey-goosey. So the key point here is, under our Act regulation, you talk about chain of custody. It's the licensee's responsibility to ensure that doesn't matter if it's going to point A to point B, that there is always a qualified licensee in charge. So in other words, they own it. So it doesn't matter if it's in the transport till its final destination, where the legal transfer takes place between a licensed entity to another licensed entity. And I'm going to keep it at a high level. Licensed entity could be a licensed entity within Canada, could be a licensed entity through import-export via US and back and forth. I would like to remind the Commission of the story of the steam generators. And the steam generator story was the licensing of steam generator to go to Sweden for applying the 3 Rs, reduce, reuse, and recycle. So the 3 Rs were going to be applied. And what the licensee is demonstrating here, they will send large objects to the U.S. where the certain metal will be recycled, certain metal will be reused, and certain metal is the waste, still Canada's responsibility, because in the U.S., in their policy of the U.S., do not accept waste. So that's why for those of us who did some code of conduct, we call them disused sources rather than waste. So very, very briefly, it's the licensee's responsibility to maintain the records. We don't have enough resources to maintain the records, and it's not our responsibility. They are licensed, and they are responsible to ensure safety. With respect to the waste management program, I'm fully supportive of transparent elements, and at the CNSC, we call them the cigars for a reason. We will be more than happy in order to address, based on the plans of the licensee, what the planned or end point will be. With respect to the tracking of the transport, the high-risk transport and the ones that require security, there is a whole licensing in place that requires a plan, and the plan most likely will require not just tracking, accompanying of the transport to take place as we go through cross borders, as we go through within Canada, or what they do in the US. And this is the high level because this information is prescribed information. So everything is being tracked, everything is being recorded, and everything is being maintained with the licensees for us to make sure that the operations is safe. At the end point is they're responsible for the safety. And if they are not, we should just shut them down.
Mr. Binder, if I could substitute, out of respect for Mr. Jamal's comment, if I could substitute the term loosey-goosey for the term lax rigor and accountability. Thank you.
Okay, any other question? Final thoughts?
Thank you. First, I want to thank the Secretariat. They do an excellent job, and I specifically want to thank them for the zip file with all of the supplementary filings. That was I think the first time they've used that, and I found it very helpful, saved a lot of time, and it was really appreciated. I want to say no thank you to the small modular reactors. I think we've had a couple of industry interveners who have offered them up as an excellent opportunity for Northern Ontario. I think Chief Glenn Hare from Anishinaabe Nation and Northwatch are the only Northern representatives here, and I think that Chief Hare would agree with me in giving a hearty no thanks to those small modular reactors. We have other options which are greatly preferable, so I just wanted that on the record. I also want to thank you for your attention.
Thank you. So we will move to the next